My name is Stephen Domanovich, and I'm a partner at Continental, based out of their Miami and their DC offices, where I'm a litigator. And I'm a former state and federal prosecutor in the Southern District of Florida and also the District of New Jersey. And I'm also one of the co-presidents of the Miami Lawyers Chapter for the Federalist Society. So today it's my privilege to introduce today's panel, which is entitled The Visibility of Bruen and the Challenges and Applications, which will address questions that go to the heart of the Second Amendment and foundational issues about originalism, tradition, and individual rights. So I'll begin with a congratulations on choosing to attend a panel that is very complicated and no court has ever had an opinion about. So I laud you for being here for those reasons. So with that, I'm going to turn over the discussion to our moderator today, and it's the Honorable Paul Mady of the United States Court of Appeals for the Third Circuit. Thank you.
Well, thanks on behalf of the panel for the kind introduction, the pleasure of joining this conversation. As was noted, the topic is the viability of Bruen, perhaps a revealing title. Right? Viability is one of those old words meaning life and survival, but I'm not sure that the life of the Second Amendment can be captured by a single judicial essay. Recall, as Blackstone explained, that having arms for one's defense is indeed a public allowance under due restrictions of the natural right of resistance and self-preservation. And since the right to self-defense from the tyranny of others pre-exists our founding, well, laws extensively regulating the types of firearms a person can possess or the places where possession is permitted could eviscerate that general right. Bruen, in short, only confirmed a principle of law. It couldn't create new legal life, nor, it seems, must it survive, right? Judicial essays, like judges, they come and they go. What matters, as Adams once wrote and others echoed, public virtue is the only foundation of republic. So it is not, it seems, history alone that matters, but reason. Of course, surveying history helps us understand the reasons relied on to regulate any right, but history alone, a search for the fossils trapped in amber, well, we already know that the fundamental rights that predate America are not unlimited, and like any law, can never license acting contrary to the common good. That perhaps is the point of Rahimi, and perhaps why Bruen's viability will depend on whether it opens up to a much older conversation, one that reclaims the principles reflected in our Second Amendment, that reveals as its determined reason and spirit a respect for the fundamental right to bear arms, along with those natural limitations that one must not use the liberty to subvert the common good. Unless, of course, that's just way too much for us generalist judges. We are exceptionally fortunate to have real experts instead today to discuss. Let me start with a brief, and I do mean brief, introduction of our guests, starting with Professor Joel Alicea, the St. Robert Bellarmine Professor of Law at the Catholic University of America Columbus School of Law and a Fellow at the American Enterprise Institute. Professor Eric Rubin, an Associate Professor of Law at the Southern Methodist University Dedman School of Law, and Professor Smith, a visiting fellow at the Oxford University and a senior fellow at the Ave Maria School of Law. I do all three an enormous disservice with that truncated introduction, preferring dialogue and discussion with our limited time. Please do take a moment to review their fulsome accomplishments available in your program materials. We will start our discussion with remarks from Professor Alicea, turn to Professor Rubin, and then give Professor Smith the last word before moving to an open discussion. Time permitting, I may turn to the audience for a question or two at the end. With that, Professor, the floor is yours.
Well, thank you, Judge Mady. Thank you to my fellow panelists. It's an honor to be here with you all, and to the Federalist Society for inviting me to be on this important panel addressing a hot topic in constitutional law, the challenges and applications of Bruen and Rahimi Among those challenges is to understand what Bruen requires, what the methodology actually is. And that has been itself a topic of contestation in the lower courts and among scholars. So that's the first thing I'm going to discuss today is what is the Bruen methodology, at least as I understand it. And when you try to apply that methodology, that raises another perennial issue of constitutional law, which is the level of generality problem, a problem that applies across constitutional law to all sorts of different methodologies, but that Bruen needs to have an answer to in thinking through historical questions in a rigorous, principled way. So I'll address the level of generality problem and how we might go about thinking about that problem in the second part of my remarks. But starting with Bruen's methodology itself. So Bruen prescribes a two-step approach to addressing claims under the Second Amendment. One step focusing on text, the second step focusing on history. So the first step asks whether the rights claimant's course of conduct falls within the plain text of the Second Amendment. So it's focused on the linguistic meaning of the text, the original linguistic meaning of the text, and it focuses on the operative part of the Second Amendment's text, asking whether the rights claimant is part of the people, whether the object that the rights claimant wishes to use is an arm, and whether the conduct that the rights claimant wishes to engage in involves keeping or bearing an arm. Insofar as the rights claimant's asserted course of conduct fits within those three textual elements, as Bruen calls them, then under step one of Bruen, that conduct is presumptively protected by the Second Amendment, and the burden shifts to the government to carry its burden at step two. The reason for that shift in the burden, it seems to me, is that Bruen seems to be presupposing that the textual description of the right is very good prima facie evidence of what the contours of the underlying natural right, as understood in our law in 1791, were. And so insofar as you have a violation of the text, that's at least presumptive evidence of violation of the underlying right. And that's why you shift the burden to the government at step two. So step two of Bruen then asks historically whether the government's modern regulation fits within the historical tradition of firearms regulation in the United States. That tradition is focused primarily on the era relating to ratification. Which ratification year, 1791 or 1868, is the right ratification year is itself an open question at the Supreme Court and a contested one among scholars. But regardless of which year you pick, that's the focus of the historical inquiry. And Bruen describes it as a historical tradition of firearms regulation. I think that's important because traditions are reflected in practices, but they are not reducible to practices. So the actual historical laws, the historical statutes or the common law, are reflections of underlying principles of the Second Amendment, but they are not themselves the principles of the Second Amendment. The way to kind of test that for yourself is to think about the way in which traditions can remain intact even as the practices that reflect those traditions change over time. That shows that what traditions consist of are principles that unite and explain the different practices. And so what we care about is looking at these historical laws as reflections of the underlying principles. And how do you go about that task? Well, you want to focus on, as Bruen says, the how and the why of those historical laws to identify the relevant principles. You want to look at why did these historical laws allow for regulation of arms bearing or arms possessing conduct, and how did they allow for that kind of regulation? And you compare the modern regulation to those hows and whys from the historical tradition to see whether they fit, the modern regulation fits within that historical tradition. And if the government fails to carry that burden, then the government loses, right? The modern regulation is unconstitutional. Okay, so that is the methodology, at least as I understand it. The next question is, how do you apply that methodology in light of the level of generality problem? What do I mean by that? Well, if we're looking at historical laws, for example, you might have, to take a very silly, trivial example that highlights the point, you might have a law that was enacted on a Tuesday, right? Is the fact that it was enacted on a Tuesday legally relevant when assessing a modern regulation. So if this modern regulation was enacted on a Monday, does that mean that it is disqualified from being part of the historical tradition? That question depends on which facts, which features of the history are legally relevant in assessing historical analogs. And that's the level of generality problem, because the more facts, the more features you build into the legal analog, the more constraining it is, the harder it is to draw analogies to historical traditions, and therefore the more likely it is that the government will fail at step 2. Whereas the higher the level of generality, the fewer features you bake into the description of the tradition, the more likely it is that the government will be able to carry its burden at step 2, right? So it's not just that it has conceptual relevance, it has real practical outcome relevance in figuring out this level of generality problem. So how should we approach that? It seems to me that the first step here is to point out that what facts are legally relevant depends on what question is being asked, what the legal question is. And the legal question that's being asked at step 2 is, does the modern regulation infringe on the pre-existing right that the Second Amendment was designed to codify? That means that the only features of the historical tradition that should be legally relevant are those that pertain to the right itself. And those features that pertain to the right itself are what I call substantive features, as opposed to incidental features, which are just facts about the historical record that are not themselves baked into the understanding of the underlying right. They are instead, like the fact that something was enacted on a Tuesday, completely incidental, not legally relevant, even though part of the historical record, right? Great. But then how do you determine what is substantive and what's incidental? And it seems to me that the way to do that is to immerse yourself in the history of the period, probably 1791, maybe 1868, and try to recover the premises, normative and political and otherwise, that era had about the right in question, in this case the Second Amendment, and then reason from those stipulated historical premises to an assessment of the relevant features. So to make that more concrete, let's take a look at the case that the Supreme Court has agreed to hear, this Hawaii law in Wolford. That's a law that switches the default rule for going onto private property that is generally open to the public. The Hawaii law says you cannot enter into land that is generally open to the public, private land that's generally open to the public, without the express permission of the landowner. Now, obviously, that means that very, very few people will give that kind of permission explicitly, maybe because they're not even aware that they need to do that. And so you're going to be effectively precluded from carrying arms on private property that would otherwise be open to the public in Hawaii under that law. So let's think about the level of generality here. The laws that the Ninth Circuit relied on to uphold that statute are generally laws that are anti-poaching laws. They are laws that targeted carrying arms onto land for purposes of preventing poaching of game on that land. It's also not clear that those laws, in fact, it seems unlikely that those laws were even about land that was otherwise open to the public. Most of them seem to have not been open to the public. But the question is, are those features relevant? Should we care that those laws were about poaching, that those laws were not about land that was otherwise open to the public? You could ignore those features, and then it just looks at a very high level of generality, like statutes that are about preventing bringing arms onto private land. And at that level of generality, the Hawaii law might very well fit within the tradition, right? But if we go and try to recover the principles of the founding, there is a lot of historical evidence that you're not supposed to interpret the scope of the Second Amendment right in a way that effectively nullifies much of the right, or that leads to the broad disarmament or broad lack of caring of the public, the arms-bearing public. Well, insofar as we set the level of generality at the high level that Hawaii and the Ninth Circuit would like it to be set in this example in Wolford, that would lead to effectively a ban on public carrying in the state of Hawaii. So that cannot be the right level of generality at which to view that historical tradition. It must instead be the case that some of these features of those laws about whether the land was otherwise open to public carry and whether the purpose was for anti-poaching or not, that those features must be relevant, legally relevant, because if they were not, the outcome would be one that would eviscerate what we know to be the historical premises and principles of the Second Amendment when it was codified. So the key move is to take on board those historical premises and principles and then evaluate the specific features of the historical tradition in light of those principles, which does mean that the judge is engaged in normative reasoning, is engaged in their own evaluation of the features in light of these principles, but they are stipulated given historical premises or principles in much the same way that when judges evaluate a new case in light of prior precedent, the prior precedent supplies the principles and premises that the judge then has to evaluate this new fact pattern in light of and decide what facts in the new fact pattern are relevant in light of that prior precedent. It's very similar to what I'm describing. It's just that instead of cases, we have historical materials that are supplying those premises and principles to evaluate the features. So I probably am going a little long there, and I'll just leave it at that. But my general proposition is that actually what Bruen is prescribing here at step 2 in addressing the level of generality problem is not that different from what judges do every day and should not be viewed as some sort of really novel or strange exercise, but is in fact something that judges are pretty good at and pretty used to doing, just in a historical context rather than in a precedential context. Thank you very much.
Thank you to the organizers of this conference for the invitation, to my co-panelists, to Mark and to Joel, and to Judge Mady for moderating. It's an honor to be here and to join in this important conversation about the Bruen decision and its future. In my remarks today, I want to do 4 things. The first thing I want to do is I want to briefly recap a principal reason for why in 2022, Bruen announced a new methodology for deciding Second Amendment cases. Then, second, I'll talk about what happened next. How after Bruen came down, judges often disagreed about how to apply the test, and that led to divergent outcomes, more divergent than many expected. Third, I'll discuss United States v. Rahimi, where the Supreme Court acknowledged that some of that disarray came from lower courts overcorrecting, striking down too many laws in response to what had been before Bruen a period of perhaps too much deference. And finally, I'll talk about what I'm seeing post-Rahimi. And I'll close with a few thoughts on why extending Bruen's methodology to other areas of law, which is something that has been proposed, is premature right now, and what we need to figure out first. I'm motivated by a pretty simple conviction. The constitutional doctrine only works if it produces stable, predictable results across cases, no matter who the judge is. If outcomes turn on the happenstance of which judge you draw or what president appointed that judge, then something in the doctrine isn't working right. Constraint, consistency, and legitimacy go hand in hand. And I think that's a good place to start because those values, constraint and administrability, were among the main reasons that Bruen used to rationalize its new test. For decades, proponents of historically grounded interpretation have argued that history constrains judges better than balancing tests and better than means-end scrutiny. And Bruen echoed that argument. Judge Thomas's majority opinion criticized the use of means-end scrutiny as, quote, judge empowering, and insisted that the Second Amendment should be applied according to its unqualified command. Justice Kavanaugh in Rahimi made a similar point in his concurrence, that Bruen's approach, quote, supplies direction and imposes a democratically infused constraint on judicial decision-making. And the promise of judicial constraint through history is very appealing. But as we all know, there is no such thing as an unlimited right. This is something that my co-panelists have already mentioned. And every single major court opinion has mentioned this too, from Heller through to Bruen and Rahimi. Every one of those opinions recognizes that the right to keep and bear arms coexists with the ability of government to regulate to some extent in the interest of public safety. And so the doctrinal question becomes, how are judges supposed to use history and tradition to decide in a consistent and predictable manner What counts as permissible regulation today? In theory, Bruen's analogical test should have made that clear. The idea was that judges would identify the balance struck at the founding between the right on one hand and regulation on the other hand, and then apply that balance to modern circumstances. In practice, though, things got messy. After Bruen, we had something like a natural experiment, a remarkable natural experiment. For the first time, after decades of academic discussions about history and text methodologies, an entire area of constitutional law, firearms regulation, was governed by a pure text history and tradition framework. And every court in the country and every judge within those courts suddenly had to apply it. Now, at this point, I respectfully disagree with a bit of what Joel said about the two-part test that Bruen set down, with one step being just text and the second step being history. There's a debate in the lower courts about this, and I think the more persuasive view is that you can't extract text from its historical context, and that text as informed by history is the appropriate step one analysis. Those are Bruen's words. But back to my comments, I want to talk about what happened after this test came forward. My co-authors and I, Rosanna Smart and Ali Rouhani Rabar, looked empirically at the first year of post-Bruen opinions. And what we found was striking, that for almost every case striking down the law, another court was upholding a similar law based on similar historical facts. The divergence wasn't narrow. It spanned the entire scope of gun laws that were being challenged in courts, from domestic violence prohibitions to serial number requirements to sensitive places laws. In one instance, the same judge reached different outcomes on the same issues weeks apart. And when we look at who was making these decisions, a pattern emerged. After controlling for case characteristics, we found that judges appointed by Republican presidents were 1.8 times more likely to strike down a law than judges appointed by Democratic presidents. A separate study by professors Rebecca Brown, Lee Epstein, and Mitu Gulati found a similar trend. And what's more, they compared it to the operation of the two-part test that had prevailed in the courts between Heller and Bruen. And they found that the partisan gap in Second Amendment rulings actually widened from 12 percentage points before Bruen to 18 points after Bruen for reported decisions. I think that should give us all pause. The promise of Bruen was constraint, and yet the results, at least so far, at least as I have seen, suggest growing ideological divergence and not less. Now, some have argued different explanations for this disparity after Bruen and before Bruen. For instance, that younger judges, many appointed in the post-Heller era, see things differently. There are other explanations. I don't find many of them persuasive, but even assuming the accuracy of some of these explanations, if the outcome in cases turns on the background of the judge, then the doctrine is not doing what it's supposed to be doing. So what explains the inconsistency? I think part of this is that Bruen left so many key elements of the doctrine underdefined. And perhaps the most indeterminate sentence in the opinion, I think, Bruen said that historical and modern laws have to be, quote, analogous enough, end quote, to be constitutional. Well, what counts as analogous enough? There's the how and why test that Joel set out, but as Judge Sutton put it, and as Joel was just talking about with respect to levels of generality, level of generality is destiny in interpretive debates. To echo the sentiment that Joel said, although I might disagree a little bit with where he took it, but I'm not sure, if you describe historical analogs at a very narrow level, say only those laws identical to the one at issue in a modern dispute, almost nothing in the modern world is going to qualify. If you frame the analogy more broadly, focusing on principles, not precise matches, the doctrine becomes more workable. I think we agree on that the appropriate test is at the level of principle. But we've seen courts split along these lines. Some zoomed in so tightly that Bruen's test became an exercise in historical literalism. That's the risk on one side. Others zoomed out, treating the inquiry as one of underlying principles, but you could do that at a very high level of generality where almost any law is constitutional. In Rahimi, the Supreme Court stepped in and clarified that the test should not be one of historical literalism, In the court's words, this is not an area of law trapped in amber. The court emphasized that the proper analysis is whether a modern regulation is consistent with the principles that underlie our historical tradition, not whether it's a carbon copy of the 18th century law. And that's an important shift. But notice the irony here. Before Bruen, the common refrain was that lower courts were mistreating the Second Amendment, treating it as a second-class right. In Rahimi, the concern was the opposite, that some courts were overcorrecting and supercharging the right by applying Bruen too mechanically. And so where does all of this leave us? I'm going to close with a few thoughts. The first one is that I think people need to take Bruen's growing pains more seriously. And that's especially true before talking about extending this methodology into other areas of constitutional doctrine. We have to make sure that it actually produces the consistency that it promises. In this regard, the Second Amendment is the canary in the history and tradition coal mine, and I think the early returns suggest that the canary is signaling some trouble, so we have to take that seriously before it falls off its perch. Second, I think that we have to take Rahimi's guidance seriously, especially with respect to the level of generality. If the test is going to function in a modern world with modern problems, it has to operate at the level of principle and not replication. The problems of the founding era, and I would extend this to poaching laws, for example, the problems of the founding era were not the same as those that we face today. And translation, not transplantation, is what will make the doctrine coherent. Anecdotally, I see some courts heeding Rahimi about principles and other courts all but ignoring it, writing entire opinions that might reference it once in passing. And third, I think that we should remember that deference to legislatures has deep historical roots of its own. Bruen was critical of means and scrutiny because it involved judicial deference, but in moments of historical uncertainty, a measure of deference isn't an abdication. I'd argue that it's judicial humility. And it's also tied to our historical tradition. As then Judge Barrett wrote in Cantor v. Barr, legislatures historically decided who could be disarmed, quote, when they judged, i.e., when the legislatures judged, that doing so was necessary to protect the public safety. That, too, is part of our constitutional tradition. I'll stop there. Thank you. I look forward to the discussion.
Thank you, Professor Smith.
I was taught that if I'm in a room with an honorable judge, I should always stand, so I'm going to stand.
So ordered.
Let me begin with some observations, big picture-wise, about the state of the battle involving the Second Amendment in America today, specifically in a post-Heller world. Since Heller, this fight has played out in two acts. Act one was post-Heller, and in that act we saw massive resistance by the lower courts who simply thumbed their nose at the Supreme Court, pretending they could not figure out Heller, pretending they could not figure out the text of the Second Amendment that says the right of the people to keep and bear arms shall not be infringed. How much clearer could you write that? While feigning this ignorance, guess what? The consequences were predictable, which is with virtually every case between 2008 and 2022, with rare exceptions, the government won and the Second Amendment was relegated yet again to a second-class right. And that gave rise to Act 2, which is the Supreme Court decision in Bruen, which really was a sippy cup paint-by-numbers way to the lower courts, the Article 3 inferior courts, no offense, Judge, that says specifically, this is how you apply Heller, and we're going to paint it out for you in a paint-by-number way, and that's what Bruen was. Heller and Bruen are the same approach, the same methodology. It's just Bruen is really written out in a paint-by-numbers way, so the lower courts could not screw it up a second time, which gives rise to what? Basically, the lower courts no longer could get away with saying, we don't understand anything about Heller. We now need to come up with a new way to engage in a rearguard action to undercut and eviscerate the right to keep and bear arms, in particular in those blue state jurisdictions where the blue slip continues to play a role into the outcome of some of those decisions. Specifically, what we've seen is an attempt in some of these lower courts to find other ways to refuse to respect the right to keep and bear arms, and I want to identify two of them right here and right now. The first game that's being played is what I call the facial challenge game. And this is basically based on the 1987 Supreme Court decision of the United States versus Salerno. In 1987, the court decided Salerno that says when you're dealing with a facial challenge that the party must succeed in demonstrating that the gun control statute, and there it wasn't a gun control statute, but that the statute itself is unconstitutional in all applications. This is what is basically known as the Salerno principle. Now, it sounds simple enough, but this is the game that we're seeing played in many of the lower courts today, and that is the judges are misapplying the Salerno principle to shut down facial challenges to modern-day gun control laws. And how exactly are they doing this? Well, since Rahimi, the lower courts have found this way of doing it, which is really kind of a version of fantasy judging, I kid you not. What I mean by that is these lower court judges are imagining in some sort of a fantasy world a narrower version, a hypothetical version of gun control statutes that are not actually the cases or not actually the statutes being litigated. Let me give you a hypothetical to illustrate the point. Let us say that someone today challenges a DC ban on handgun possession. And let's pretend for the moment that Heller does not exist. The district court playing the Salerno game would do the following. It would say this. Well, we know that it's perfectly constitutional under the Second Amendment to ban felons from having handguns. So therefore, there's at least one constitutional application to a handgun ban in DC. Therefore, the facial challenge to the DC handgun ban is constitutional, or it falls by the wayside and cannot be sustained on a facial basis. Of course, the problem is with that hypothetical statute dealing with the DC handgun ban, there is no element in it that says you have to be a felon. The statute as it was written is unconstitutional in all of its applications because that felon element that hypothetical court would use as the hook to uphold the statute is not actually in the statute. In essence, they were rewriting, or they would be rewriting a statute that's being challenged in the abstract compared to the actual gun control laws being challenged in the real world. So before we go any further to illustrate the problem and how this is getting played, I want to put out some general principles. To begin with, a facial challenge to a gun control statute is a claim that the statute is unconstitutional in all its application, not just to the specific case in front of it. Now, this, of course, contrasts to what are known as applied challenges, which argues that the statute is unconstitutional when applied to the particular facts of a particular plaintiff. Now, understand this distinction between facial challenges and as applied is extremely important for Second Amendment litigations, because here's a real-world example of how it plays out. Just a couple months ago, the United States Court of Appeals for the Fourth Circuit in a case called Lefebvre versus Fairfax County upheld a ban on handguns and all firearms, frankly, in parks in Fairfax County. Now, there are 420 parks in Fairfax County, consisting of 24,000 acres. That's over 9% of Fairfax County as a park. To put that in perspective, by the way, that is almost twice the size of the borough of Manhattan, which the Supreme Court in Bruen said specifically you could not declare the borough of Manhattan a sensitive place, a gun-free zone, constitutionally under the Second Amendment. And yet that's what the Fourth Circuit did. And how exactly did they do that? There are four parks in Fairfax County had preschools in them out of the 420. So what did the Fourth Circuit do in light of that? And how did they use the fact that 4 of the 420 parks had preschools in it to uphold the law and deny the facial challenge? They said simply this. They said, well, look, the Supreme Court has said in dicta that firearms can be banned in schools. That's what they indicated in Heller. And because 4 of the Fairfax County parks have schools in them, a facial challenge to that law that says no guns in the parks is upheld because there's at least some constitutional application to at least the parks with the schools, and therefore facially you cannot knock the law out. And that's what Chief Judge Albert Diaz wrote when he says, quote, "That's enough for us to reject the facial challenge." Of course, what the Fourth Circuit did here wrongly is they imagined a statute that said no guns in parks that happen to have schools. But this is wrong because the hypothetical statute that actually has an essential characteristic of a school in a park in Fairfax County was not the actual statute that was being challenged, because the statute simply said no guns in parks in Fairfax County. So they invented a law, sort of a straw man law they invented, and then they analyzed the law under the Bruen methodology and then upheld the actual law, even though the actual law was written differently than the hypothetical law that they used to knock out the facial challenge to the actual law. Indeed, if you think about it from the perspective of a prosecutor to convict a defendant of carrying a gun in a park in Fairfax County need only show that you had a gun in Fairfax County in a park and you're convicted. The presence of the school is not relevant. The prosecutor doesn't have to show the presence of a school to win the case. And yet it was the presence of the schools in the parks in Fairfax County that was the hook that allowed the court to deny the facial challenge. And this is not correct, because the actual laws have to be analyzed and not some hypothetical law. Now, is there a solution to this problem, which we keep seeing over and over and over again in the lower courts? And the answer is yes. And that is, take a look at what the Supreme Court did in Heller. Heller in 2008, of course, literally said that the District of Columbia's handgun ban was facially unconstitutional. But guess what the Heller case also said simultaneously with that holding? It literally says, well, it's true that the Second Amendment might permit bans on felons possessing firearms. It might permit the ban on fully automatic machine guns. It might allow for bans in government-mandated gun-free zones or sensitive places. Now think about that for 1 second. Despite the Supreme Court in Heller saying that the Second Amendment would permit the banning of these items consistent with the Second Amendment, it still knocked out the gun ban, the handgun possession ban in D.C., notwithstanding that. And why is that? Because the Supreme Court analyzed the actual statute written and did not say, because there's some hypothetical fantasyland statutes that could have been written, that could have been constitutional, we're not going to rewrite that for D.C. But that's exactly what's going on with the lower courts right now. Oh, sorry about that. I'm just timing myself. Now, keep in mind about Heller and facial challenges. The Supreme Court in 2015 in Patel versus City of Los Angeles literally called the Heller case a facial challenge and really an exemplar of it. And that is because it was. So whenever someone is faced with a facial challenge in a Second Amendment litigation and you have the Salerno principle thrown at you, keep in mind what Heller actually did. Now, what you often see now is that some advocates for the gun control side of things say that, well, Rahimi knocked out a facial challenge, so that shows what we should be doing, and Rahimi is always cited for this. But look at the statute that was challenged in Rahimi. Rahimi was an extremely detailed statute that says that right, it's 18 U.S.C. 922 G8, a prohibited person statute, that said that if you can be banned from having a gun if there's a restraining order found by a court and a credible finding, or a finding that you are a credible threat to the physical safety of another person. It's an extremely detailed statute. And the Supreme Court analyzed all of these and concluded that under the Second Amendment's history and tradition, it is the case that you can be temporarily banned from possessing firearms if you are found by a court to be a violent danger to someone else. And therefore, they uphold the Rahimi law by actually looking at the actual lawsuit. Of course, this is much different than what the Fourth Circuit did, which again, they added elements to the statute that was being challenged to save it. And that is simply not appropriate. Now, there's two reasons policy-wise why this is totally wrong. One is a separation of powers problem. You should not have courts rewriting statutes and then discussing them. They should analyze the statute as written. And as a practical matter for those people that represent Second Amendment rights claimants, by eliminating facial challenges to gun control laws, you make it much more expensive, much more difficult and time-consuming to ultimately win those cases. And it makes no sense to say that these facial challenges cannot work, because let's think of a more basic hypothetical example. Let us say that there is a law that bans guns in a county or in a state or in the country. Well, we know the Supreme Court has already said that there are so-called sensitive places where you can ban guns. So that means in every county, there's at least a prison and a courthouse. So means you cannot facially challenge that no guns are allowed or no guns can be possessed in the county. The same for the state, the same for the country. That is simply an absurd result and cannot be the case. And I will just say an excellent example of a court getting it right was the Illinois Supreme Court in People versus Burns in 2015 that said that the Illinois had banned public carry without mentioning the felon element. And when the state of Illinois prosecuted Mr. Burns, who actually was a felon, the state Supreme Court said, you can't do that because the law doesn't talk about felons. And here's what the court said. An unconstitutional statute cannot become constitutional simply because it is applied to a particular category of persons who could have been regulated had the legislature seen fit to do so. And that, of course, is the point. So to conclude on this point, judges need to assess the laws as written. They should not invent elements that don't exist and then opine on the legality of those hypotheticals. Now, the second main area where we're seeing games being played is this critical distinction that no one talks about because no one thinks about, and that is the distinction between legislative facts and adjudicative facts. By mislabeling, this is a big deal, folks, in the real world, because by mislabeling legislative facts as adjudicative facts, lower courts are forcing Second Amendment rights claimants to engage in unnecessary and time-consuming litigation processes. And this legislative fact versus adjudicative fact issue is extremely important because a lot of these bad gun control laws are in bad jurisdictions where the judges, frankly, as Eric kind of alluded to, are kind of down on the Second Amendment. And again, I think the blue slip process in the Senate contributes to this. Now, here's the thing about this. Judge Posner in the Seventh Circuit in Moore versus Madigan drew this distinction between the two. And again, this is often ignored in litigations, but it shouldn't be. In his opinion in Moore versus Madigan, which is a Second Amendment challenge to an Illinois ban on guns in public, he offered this critical difference or distinction between legislative facts and adjudicative facts. Judge Posner wrote, legislative facts bear on the justification for the legislation. Adjudicative facts concern the conduct of the parties in the particular cases. Judge Posner went on to say that only adjudicative facts are determined in trials and only legislative facts are relevant to the constitutionality of, in that case, the Illinois gun control law. Now, this is quite important because the Supreme Court draws this critical distinction between legislative facts, which is about the law, the Constitution, versus adjudicative facts, which is about the parties. If you look at the Heller decision, if you look at the McDonald decision, if you look at the Bruen decision, if you look at the Caetano decision, if you look at the Rahimi decision, what do they all have in common? None of them involved expert testimony, none of them involved witnesses, none of them involved discovery, none of them involved all the sorts of things that you see in a normal litigation involving adjudicatory facts, which is, did Mark drive the car through the red light? Did Mark run into the tree? Did Mark get kicked out of the bar? Whatever it is, because when you're talking about the Second Amendment issues and whether or not something is constitutional or not, those are legislative facts that do not require the same sort of process and trials and time-consuming money spent that you see in a normal case dealing with adjudicatory facts. Now, by the way, if there's any doubt that the Supreme Court views legislative facts differently than adjudicatory facts, you only need to look at Heller and Bruen specifically, because in both cases, parties asked the Supreme Court to remand the case back down to the lower courts for more fact-finding, for more evidence. And in both cases, in Heller and Bruen, the Supreme Court said no can do. In Heller specifically, the Solicitor General Paul Clement literally asked the Supreme Court to remand the case back down to determine whether or not the handgun ban was constitutional, and the Supreme Court says we don't need to do that. We're going to decide it right now. The handgun ban is unconstitutional because handguns are protected arms, period. Likewise, in Bruen, if you take a look at the dissent, it talks all about, from Justice Breyer at least, the importance of having more fact-finding, remand in this case for more fact-finding, because that's what New York needed to assess the licensing regime. And again, in Bruen, the Supreme Court says, no can do, we don't need to do that. These are legislative facts, we don't need more evidence, we don't need a trial and the like. And just to summarize why legislative facts versus adjudicatory facts is mission critical in the real world of Second Amendment litigation is because they're governed by different rules. With legislative facts, Courts have unlimited investigative authority. The rules of evidence do not apply. There's no authentication. There's no hearsay concerns. There's no Daubert issues. You don't have to spend time and money wasted on experts and expert depositions. Appellate courts, like Judge Mady here, gets to review all the decisions de novo, so the trial court findings are not entitled to clearly erroneous deference on appeal. And again, the reason makes a lot of sense, because if you think about it, if you're trying to determine the meaning of the Second Amendment, you don't want the meaning of the Second Amendment to get screwed up because some lawyer dropped the ball on some sort of particular issue. So you always want to give the courts the ability to use legislative facts to understand the meaning of the Second Amendment. And if you want to have a great example of this, one need look no further than Justice Sam Alito in his concurrence in the Caetano case in 2016, where he talks about stun guns. And in that discussion of stun guns, did he ask for expert testimony and more fact-finding in the lower courts? No, he did not. Justice Alito literally cited to a Michigan case, citing to a law review article, citing to a 1985 newspaper article, because that's how legislative facts work. So again, those are the two things you need to pay attention to: the facial challenge game that's getting played to knock out Second Amendment challenges, and the distinction between legislative and adjudicative facts, because if frankly, the government defendants are always asking for adjudicative facts because it drags the case out for years when it doesn't need to be. And don't take my word for it. Just look at how the Supreme Court has decided Second Amendment cases time and again. They use legislative facts. They don't need trials, experts, and discovery and the like. Thank you.
Thanks, Professor.
Thank you, Professor. I want to take the discussion back to the beginning and sort of see if we can reach agreement as to what Bruen Rahimi is and what it isn't. And as I understand you, Professor Alicea, you see perhaps Bruen as nothing new. It's the kind of analogic reasoning that courts have been doing for a very long time and continue to do so in many other areas. And certainly when we think about the role of the state courts, it's something that is the ordinary practice of the judge. Professor Rubin, I hear you to argue that no, this is very different. This is something we haven't seen in American jurisprudence before, and so we need to be careful to understand it before we even consider expanding it. So, Professor, I'll start with you. Is this old or is it new? And if it's old, how come it's proven so complicated?
So the methodology is new in the sense that it's the first time that you have an individual rights provision of the Constitution that's being governed entirely by text and history. As Eric said, I think he's right about that. I don't think it's new in the sense of what kind of skills have to be deployed to do the methodology well. That's the distinction I would draw. And I would say, in response to Eric's point about the divergent outcomes in the lower court, that and by the way, that research from Eric and from Rebecca Brown and others, very much worth reading. Very interesting empirical analyses of how the lower courts have been handling Bruen. He's not really convinced by any alternative explanations, but I'll offer one anyway, and then he can shoot it down if he wishes. But Eric's own paper and the paper from Professor Brown as well showed that the spike in disagreement among the lower courts about Second Amendment cases began around 2016, 2017, well before Bruen. And what might explain that? Well, a lot of things might explain that, but it seems to me that one potential explanation for why you start seeing that spike in disagreement around that time is that you have the abolition of the filibuster for judicial nominees a few years earlier. And you're starting to see by that point the results, the fruits of more polarized judicial appointees because of the lower threshold for judicial appointment in the Senate. And then that just plays out moving forward with Bruen's methodology as well. So I don't think it's the case. I think that's a huge confounding variable at the very least to try to draw any significant implications from just looking at how much disagreement is there in the lower courts right now. It's like, well, I'm not at all surprised that there's a lot of divergent disagreements in the lower courts right now about such a hot button constitutional topic, given that you've got more divergent judicial philosophies among the judges who are being appointed in a post-filibuster world. That I don't think that says anything really about Bruen as a methodology.
I want to let Professor Rubin respond to that. I'm going to add another just hypothetical as to what may be driving the divergence, which is judges just don't listen. it is entirely possible that Article 3 judges, insulated from any political accountability, simply don't follow the law. They read Bruen, they don't like Bruen, and so they will simply apply something different. If that's possible, is that divergence, or is it simply a symptom of a greater problem with respect for legitimate authority?
Taking that last point first, I think it bears re-emphasizing that the problem that the Supreme Court identified in its most recent opinion is not judges just not like, I mean, maybe it's judges just not liking Bruen and applying it too mechanically to strike down laws. But that was the problem that was addressed in Rahimi. It was judges reading the methodology too narrowly and too cramped a way to strike down laws. And with respect to the blue slip and the fact that maybe judges are just more ideologically divided these days, I don't know, I would have to think about how I could set up an empirical way to test that. I would say, though, that one difference about the Bruen methodology than what's has been done before, and I'm thinking about tiered scrutiny in particular, and this is one of the reasons that tiered scrutiny was critiqued, was that there was a safety valve in close cases of legislative deference, of deferring to the legislature. It's one of the reasons why a lot of people didn't like it. It was criticized for that. And I think that's actually a reason why there is more consistency. That has to be one of the factors. That in a lot of the very, very hard cases, when judges couldn't necessarily take their own ideologies out of the picture, they deferred to one of the elected branches. To the extent that the Bruen test removes that safety valve and forces judicial decisions even when the history is contested because history does not speak with one voice, then the test itself could be distilling some of those political ideologies, I would suggest.
I'd just like to say two things. One is the issue about whether or not Bruen succeeds is extremely important to the entire experiment of originalism, because unlike other aspects of the Bill of Rights, which we've had decades and decades, and Joel, you've written about this, you've had decades and decades of barnacles of liberal judicial activism going back to the 50s, right? The Second Amendment is unique in that you don't have those barnacles that need to be overturned and tossed out, like Humphrey's executor, just as an example, right? So I think if you cannot make originalism work in the context of the Second Amendment, where you're really writing tabula rasa, you can't make it work anywhere. That's number one. And I think, Eric, a reason probably why you saw a lot of consistency in rulings, maybe pre-Bruen and all that, is probably because where are the gun control laws being litigated? You're never going to see an assault weapon ban litigated in like the Fifth Circuit because Texas, Louisiana, and Mississippi are not going to pass gun control laws like that. So what happens is the reason why you saw consistency, I think, pre-Bruen is because all the Second Amendment challenges were in New York, they're in New Jersey, they're in California, they're in Illinois, they're in Hawaii, and the same judges that were picked by the Chuck Schumers and the like are the same judges overseeing the same laws passed by these politicians. So it's all entirely consistent, but I don't think it tells us anything about Bruen, the Second Amendment, or anything else, because I would expect that to be entirely consistent because you're only going to be challenging these laws in the areas of the country that are going to be very deferential to the government and very, let's just say, they don't like the Second Amendment as well as that.
I think that might oversimplify it a little bit. They also were the Dick Posners and the Wilkinsons and the Esterbrooks. So it wasn't, I don't know that it was just, to the extent the Chuck Schumer comment was about this being just democratic. I think there was more ideological consistency within courts and also across courts.
What about Rahimi? We've talked much about Bruen, but there is another case at play. Do we see Rahimi as contrasting with Bruen, complementing what the court started? What is it that we should take of the mixed message that comes from that second part of the framework?
I think Rahimi is part of the normalization of the Second Amendment. I think it really is a reaffirmation that the Second Amendment is going to become like any other aspect of the Bill of Rights, where you're going to have multiple Second Amendment cases every term, just like you have 3 or 4 Fourth Amendment cases a term, a couple First Amendment cases a term. And I think really it's going to get, to me, Rahimi is kind of the start of the fleshing out of Second Amendment jurisprudence in kind of a normal way. You had sort of these epic, I don't want to say country altering, because that's not really true, because it's really a restoration of the right, but you do have some major precedent-setting decisions in Heller and Bruen, and now I think okay, let's start applying the methodology to these individual types of issues and deal with them in the normal course, no different than you would do in the Fourth Amendment context on unreasonable searches and seizures and what that means in 1,000 different cases.
I agree with that completely. And, I think one of the big questions is going to be whether through this sort of common law constitutional building on top of Bruen, refining the test, whether the Supreme Court in the cases that it's hearing is going to be able to, from my perspective, I think this is really important, going to be able to provide the sort of constraint and consistency that we need for doctrine to really work as doctrine in the lower courts, or whether it won't be able to do that. So that's something that I'm definitely looking for as the court continues to take cases. I mean, the court said in Heller, it said in Bruen, I don't remember if I mentioned this in the Rahimi, that it can't cover the entire field. It's doing something fairly new with respect to the methodology. Even if analogical reasoning is always something that lawyers do, this sole focus on history and tradition is something new. And so everyone expects more litigation. The Supreme Court has to decide more cases in order to bring some discipline to what is happening in the lower courts. And I do think that is normal to an extent. The big question is whether or not the decisions and the refinements are going to be enough to bring about the consistency that was promised.
Yeah, on that point, so I agree with Eric, I think entirely on what he was just saying, that insofar as the empirical research that Eric has put forward and that Rebecca Brown and others have put forward is used to say Bruen has been a failure now, the methodology is a failure because of the divergent outcomes, that strikes me as wildly premature for exactly the reason that Eric just described, which is Bruen is a landmark, it's a watershed Supreme Court opinion that's ushering in a methodology and wiping out the methodology that all courts of appeals had been using before that. And of course, it is going to take time to flesh out what the implications of that methodology are in all sorts of contexts. That's true for any watershed Supreme Court decision. And so it strikes me as a sort of one-way or a one-sided demand for logical and or outcome consistency to say that the Warren Court Revolution, for example, which has all sorts of vague tests that are just complete nonsense, like those types of tests, those are great. But this test, which it might take some time to flesh out, this is a doomed failure because we've only had a couple of years to figure out how it applies in different contexts. That strikes me as completely unfair. I don't say that's what Eric's saying. I'm saying insofar as people use Eric's research for that purpose, I think that's unfair. And to get back to your question, Judge, about Rahimi, I see Rahimi as fully consistent with Bruen. This puts me in a category of like one or two legal scholars in the academy who think this. But I just think that Bruen just says exactly what Rahimi ends up saying. It's just that Rahimi is saying it more explicitly because apparently most of my fellow legal scholars and some judges just didn't understand what Bruen said. Bruen says that its methodology involves applying old principles to new situations. And it describes the relevant focus of step 2 as traditions, not as the individual practices, and indeed disclaims the idea that you need to find an analogy to the specific individual practice. And so to say that Bruen was this sort of wooden, rigid methodology that doesn't depend on principles, but instead requires you to kind of match it up to the specific statute and only that statute, is a complete misreading of Bruen. Rahimi simply clarifies what I think was already there in Bruen.
What of step two? And the criticism that some have raised that the absence of historical evidence of a principle doesn't mean that there wasn't widespread acceptance of the ability to take action according to that principle. In other words, legislative maximalism can still exist even if there was a minimal application given the time and circumstance. That shows up in any number of judicial opinions. Is that a legitimate criticism or framing of step two? And if not, why so?
I think that is something that we noticed right after Bruen came down, that there was a risk of overreading historical silences. And this is something that we saw in some of the lower courts before Rahimi, that there would be a modern law addressing a modern day problem, say guns on airplanes. This wasn't an actual litigated case. This is just hypothetical, a very modern problem. And then in trying to find a historical analogy, they'd say, oh, well, there was no analogy. There's no historical law that we can analogize to. Well, maybe that's because the historical legislatures couldn't even imagine the problem. Say the problem from machine guns, violence, mass shootings, for instance, just didn't exist back then. Or something else. They were more concerned about the fires that started from black powder that was stored unsafely in houses, which is not a problem that we have today. So the problems were just different. And on top of all that, maybe it just wasn't a priority. That's why they didn't legislate. There are lots of reasons why we don't legislate maximally. And so I do think that presents a risk of overreading historical silences, and it ties into the level of generality question. If we're going to be looking for actual legislated solutions to problems that did not exist in the same way at the founding, then I don't see a future for the doctrine. And only by moving up a level of generality to principles can we get around that. The big question, and this is something that there's no obvious answer to, is how high up do we have to go? Joel gave a principle, well, if you go so high that it eviscerates the right, then that can't be the level of generality. Sure, but then there's a lot below that. How do we calibrate the level of generality for which we're supposed to articulate both the right and the regulation?
Yeah, and I use that example because it's the most straightforward way to illustrate the point about how to address the level of generality problem, and because even though it might seem obvious to us here on stage, the Ninth Circuit still got that wrong, right? And so it's still up at the Supreme Court right now for exactly that reason. But I think that what Eric said is all well taken. I don't think I disagree with anything you said there, Eric. That the level of generality does influence how you think about the historical silence issue, because insofar as you think that step two requires you to match up the modern regulation with specific practices from let's say the founding, then you really are requiring the legislature to have addressed every conceivable problem at the founding in order to have produced the data set for making that kind of analogy work at step two. And that can't be correct, right? Which is further confirmation that that's not what Bruen was prescribing, unless you're going to interpret Bruen to be nonsensical, right? So if you interpret Bruen to make sense, then of course it's not requiring you to do that. It's requiring you to instead find some principle that was baked into the understanding of the right at the time of ratification. And it would be a very strange principle about the right that makes no appearance in the historical materials. That would be a silence that would be quite telling. It'd be very odd if at the founding there was some understanding of the right that no one ever articulated in any legal source. And so step one, first of all, presumes that insofar as you have a violation, and I made this point earlier, insofar as you have a violation of the text, that is presumptive, that is good evidence of violation of the underlying right. And I've argued elsewhere for why that's actually a sound presumption. And so because we are presuming after step one that there has been a violation of the underlying right, it makes sense to then say, okay, well, is there any reason to think that that presumption is wrong historically? And insofar as the government cannot point to any historical principle to justify its modern regulation, then I don't see how the argument could be, but there might be one that existed and no one ever articulated. It's a secret principle. And so it seems to me entirely sound, once you understand the right level of generality at step two, to say that lack of evidence, historical evidence for the principle, dooms the government's effort at step two.
I think there's three quick things to add on. One is you can never really have absence of historical evidence because you literally have the text of the Second Amendment, which to me is the ultimate historical evidence of what people thought, right? That is the historical evidence to begin with, which is why the presumption is if it's implicated. The other thing people often forget is the footnote in Bruen that talks about the Sir John Knight's case. If you look at that footnote, I think it's footnote 13, I can't remember now, but the point is the one talking about Sir John Knight's case, it specifically says that to the extent there is ambiguity in the historical record, we, the Supreme Court, will opt for or choose to go with the interpretation of the history that is most consistent with the unqualified command of the text. So when there's any doubt, really, the tie goes to the runner in baseball, as they say, the tie goes the text here. And the last thing is to keep in mind, the historical tradition can be doesn't have to be a one-way ratchet in favor of the legislature. It can be a one-way ratchet in a sense in favor of freedom. Because there's a great line that Chief Justice Roberts put into Rahimi where he says the law is not trapped in amber. And many people interpret that as, that means we can expand the scope of regulations in the 21st century that we could not do in the 18th century. But that's not really true because the Supreme Court in Heller literally said that it's possible that at the time of the founding, handguns could be banned because they were not usual, but today you cannot ban handguns in the 21st century because they're in common use and thus cannot be dangerous and unusual. So that's an example where if the law were trapped in amber at the time of the founding, in theory you could ban handguns today, but that is the absolute opposite of what the Supreme Court did in Heller because yes, the law is not trapped in amber, that doesn't necessarily work in favor of the government in all cases.
On the common use point, most, if not all, of the legislation seeking to restrict the right to bear arms centers on either practices or arms that are in widespread common use. After all, there's very little point in legislating something that is niche and unusual. Bruen seems to create another presumption regarding the unlawfulness of those regulations. So should that mean that courts need not much go further than the common use test? And if so, how do you see that fitting into what the framework of Bruen, maybe step two is?
Well, no, Bruen actually simply reaffirms Heller on the in common use test. And that's a great misunderstanding that if you look at the language that, frankly, the governments like to quote, that talks about how when you're dealing with an unprecedented societal concern or a technological issue that didn't exist at the founding, you may have to be more nuanced in your approach to analogical reasoning. But the part of that sentence that is never quoted in briefs or in court opinions upholding gun control laws is the first clause of that sentence that literally says, while cases such as Heller and in this case Bruen are easy to understand, in other cases you may have to be more nuanced because of technological changes and or because of societal concerns that didn't exist at the time of the founding. So when you're dealing with the in common use test, you're essentially dealing with the derivative of the historical tradition of regulating dangerous and unusual weapons. And of course, if something is ubiquitous, it's in common use, and by extension, it's not dangerous and unusual. And I should also note that we're dealing with the in common use test for arms regulations, as well as dangerous and unusual. All that occurs at the historical tradition level, which means, and this is often screwed up by the lower courts, the burden of proof to show that an arm is not in common use is on the government. There is no burden on the part of the Second Amendment rights claimant to argue and prove that an arm like an AR-15 or a handgun, whatever it is in common use because it takes place at the historical traditional level, and that is where the burden is on the government. And therefore, the government has to show that if they're regulating a gun, if they're banning a weapon, whatever it is, the burden is on them to show that it's not in common use and thus dangerous and unusual, among other things. And that burden often gets flipped if you look at a lot of the lower courts.
There was a lot there. And trying trying to think about where to intervene.
Just agree.
Just agree.
Make it easy.
So a few things. So first, I think that one ground for critiquing Bruen is its finding that a general and persistent societal problem is urban handgun violence. Since there wasn't an urban handgun violence at the founding, I've never really understood where that came from. The handguns made up less than 10% of the stock. People didn't live in urban centers. And yet Bruen says that this is a simple case because it's a persistent societal problem of urban handgun violence. With respect to common use, one point of disagreement with Mark is just that I view common use as part of the textual inquiry because that's the way that Heller seemed to frame it out. I know you're going to disagree with me about this, but Heller, when it got to common use or dangerous and unusual, was inquiring, let's look at the sorts of weapons that are protected by the right. In Bruen, in Section 3A, it's going through, it's a textual analysis. And what does it ask with respect to the guns that they wanted to carry, the handguns? They said there is no dispute that these are in common use, right? So common use is something that has come in along with the textual analysis of what counts as an arm. And this is one reason why I don't think it's simple enough just to say, look, the language is as clear as day. I think most judges would agree that even though missile launchers are handheld weapons, they're not covered by the Second Amendment, right? Arms don't include missile launchers. And so I think there's more to the textual step than is set out. With respect to common use, the test itself, I think that it's an odd test that was formulated not, as I see it, from originalist grounds. It was plucked out of the Miller case, which the Heller majority otherwise disagreed with at length. But the common use test persists. The Supreme Court has tried to say that it's the same thing as the historical regulation of dangerous and unusual weapons. But I see it sort of as this part of modern Second Amendment doctrine that doesn't have historical roots, that's rooted in the Miller case, and has all sorts of problems. It incentivizes the government to step in really fast and regulate before a weapon becomes into common use. The incentives are off. It's unclear what the principled basis for this is as part of Second Amendment doctrine, but it's what we've got right now.
Well, if you look at Heller, it specifically literally says in Heller, Justice Scalia says that there's a historical tradition of regulating dangerous and unusual weapons. The fact that they call it historical tradition suggests it's part of the historical tradition analysis. As to the originalism, right, the idea of bringing your own commonly owned firearms with you to militia musters, which is the part of the preparatory clause, of course, makes commonly owned firearms consistent with originalism. And to the extent there's questions about urban handgun violence, I would say John Adams and his clients and the patriots that were shot in the Boston Massacre would beg to differ, because the central part of Boston was literally where the Boston Massacre took place. And in the oral argument in the Boston Massacre trial, John Adams, our founding father, literally turned to the court and said that I have no doubt that the patriots in downtown Boston had every right to be armed. They just could not use the arms in a threatening way, which is why my clients, the British soldiers, were able to defend themselves. So I think that it's part of originalism. It's violence in downtown areas with guns, is the Boston Massacre, which was even before our founding. So I think there's answers to all that.
I want to get Professor Alicea into on the common use point, but then something that Professor Rubin mentioned as well, this question of whether step one is a purely semantic exercise. Should not some extrinsic materials be consulted? And if so, doesn't that mean that there is at least some historical inquiry? So maybe if you could wrap those two together.
Sure. So I'm glad you asked that, because I was hoping to circle back to it after Eric's opening remarks about arguing that you have to consult history in thinking through step one. I don't disagree with that, Eric, to state it at that level of generality, I guess one could say, that there are, insofar as step one is a textual analysis, which I think is very obvious and very clear from what Bruen says. It describes step one as a plain text analysis. It uses textual many, many times to describe the first part of the analysis. That analysis, even if you're just focused on the original linguistic meaning, will require some historical context to disambiguate among various potential original linguistic meanings. The good news is that Heller already did that in part one of its opinion, where it goes at length into the original linguistic meaning of the Second Amendment and uses history to disambiguate different potential meanings, some more capacious than others. And so to that extent, historical context and inquiry is appropriate, but it's already pretty much been done by Heller for step one. In terms of this common use question, I read the opinions differently than Eric does. I think if you go back and look at Heller, you will see that the Heller opinion is doing an original linguistic meaning analysis for pages upon pages about the Second Amendment, and then pivots later to say, and now we're going to see whether history confirms that linguistic meaning. And after it does that, it then turns to this historical potential exception to the scope of the arms that are protected and describes the historical tradition of the common use tests. In Bruen itself, as you were saying, Part 3A, and I completely agree with you here, Eric, insofar as you are gently criticizing the opinion for being kind of unclear on this point. I don't know if you were, but if you were, I agree with it, that the opinion, I think, could have been more clear about how the common use test figures in Part 3A of the opinion. But the way I read that part of the opinion is it's saying, of the three textual elements, people, arms, and then keep or bear, people and arms are just not at issue in this case. Everyone agrees that these rights claimants are part of the people. Everyone agrees that these rights claimants are trying to keep or bear an arm, something that qualifies as an arm. So it dispenses with that in like a paragraph, those two parts of the analysis. And it does both step one and step two for those two textual elements in that first paragraph, and then moves on to what's actually at issue in the case, which is the conduct element and whether caring is bearing. And there, in the rest of Part 3A, that is all textual analysis, where it says on its face, caring is bearing. And then the whole rest of the opinion is historical analysis, step two, to see whether the government bears its burden. So it seems to me that the best reading of the opinion is that it is consistent with the idea that the common use test occurs at step two, and that the only reason that Bruen seems to do that in Part 3A is because it's doing both step one and step two simultaneously in 3A for the two textual elements that are not even at issue in the case before moving on to the actual problem, which is the conduct issue.
We are bumping up against the clock here, Eric, if there's a summation point to that.
Yeah, sure. So, I think that I'm happy that we're talking about this. These are the sorts of doctrinal conversations, by the way, that I think to have to happen if the doctrine is going to have the constraint that I talked about at the outset. One of the concerns that I have with an analysis at step one that just construes the right super broadly, basically doesn't put a burden up at all for the plaintiff, is that it in effect creates a presumption of unconstitutionality in practice. And the Supreme Court said over and over again that the idea is that there was a balance between right and regulation struck at the founding, and that we have to apply that same balance today. If the right side of the equation gets construed very, very broadly, but the regulation side gets stuck back in a historical analysis that often is happening in a cramped way, then the risk that we run is that balance that was struck at the founding over time is going to look nothing like the balance between rights and regulation that we have today. That's my ultimate concern. That's my doctrinal design concern.
A final word?
The text proves the right? It's the ultimate historical evidence as I see it. And to the extent the legislator, the government wants to show there's an exception to that, really it should be a pretty heavy burden for them to show there's an exception to the textual right. It's kind of the flip side of, let's say, the Dobbs case, where if you're trying to prove the existence of a right that does not appear in the text, well, it's a pretty heavy burden to show that there is such a right that's recognized in American history. So since there's a textual right to the right of the people to keep their arms, it's textual. I think the historical evidence at the end of the day should be consistent with what the Bruen footnote said. To the extent there's any historical ambiguity, frankly, freedom should prevail and the government should lose.
Best conversations always end too soon. I want to thank the panelists for this extraordinary exchange and thank you all for your participation.